Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about section 9 of the Evidence Act, when fact not otherwise relevant becomes relevant. In my last class, I talked about section 8, talking about things done or said amongst conspirators would be admissible in court, and then I perused through the relevant provision of section 8 sub 1, sub 2 and sub 3, as well as certain case laws including Osho versus the state, Quadshare versus the state, Ubeiru versus the state, Mohammed versus the state, amongst others. In today's class, we'll be talking about when facts are not otherwise relevant would become relevant, section 9 of the Evidence Act. And with that, what does section 9 say? Fact not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact. By themselves or in connection with other facts, they make the existence or non-existence of a fact in issue or relevant fact probable or improbable. Now, to explain this, if any fact or facts are capable of rendering facts in issue probable or improbable, then they are deemed to be relevant. Apart from the word highly, before the words probable or improbable in paragraph B of section 9, the rest of the section is a reproduction of section 11 of the Indian Evidence Act of 1872 as amended, word for word. It is submitted that judicial and scholarly commentaries on section 11 of the Indian Evidence Act will be highly persuasive in interpreting section 9 of the Nigerian Act. In the case of RANGAYYAN versus INNASIMUTHU, I know I pronounced that like a Yoruba man. I'm very sorry. There's no way I would know how to pronounce it like an Indian. But then you get the gist. So now the court in this case held that by the provision of this section, collateral facts which by way of contradiction are inconsistent with a fact in issue or a relevant fact are made relevant and therefore admissible. The above opinion does not detract, that's diminish in value, from the interpretation given by the Supreme Court of Nigeria on the equivalent of the Evidence Act. In the case of AKINGBADE versus ALIMOSHO, the plaintiff, who had sued for declaration of title, tendered in evidence deed of conveyance executed by his vendors in favor of persons who had bought surrounding lands. The plaintiff's intention was to prove that his title was valid, since the neighbors who had acquired from the same vendor had long developed their land and were occupying it undisturbed. The Supreme Court held that the procedure adopted by the plaintiff was okay and that those deeds were relevant and therefore admissible under section 12, now section 9b of the Evidence Act, as they make the fact in issue, the fact that he owns the land, more probable. Also, in the case of CHIEKE versus OLUSOGA, the appellant, an Igbo man, had fled Lagos during the Nigerian Civil War, leaving behind his family. He had, by a memorandum, authorized his wife to sell his landed properties to willing buyers. When the appellant came back after the war, he discovered that one OLUSOGA was in possession of his property, claiming that he had bought it from the appellant's wife. On appellant's contention that he had not authorized his wife to sell, evidence was called and allowed in by the learned judge using section 12b of the old Evidence Act, now section 9 of the new Evidence Act, to show that the same memorandum from the appellant to his wife was used in selling other properties of the appellant to other buyers. The procedure was challenged at the Supreme Court of Nigeria. The Supreme Court held that it was good practice to produce evidence showing the circumstance and facts surrounding the sale of the appellant's other properties to prove the appellant's wife had full authority to sell the property in dispute to the respondent predecessors in title. In the case of ANAGBADO versus ANAGBADO, this case makes me laugh a lot because I'm very sure the judge must have also laughed. Plaintiff sued wife for divorce, claiming she had been maltreating and abusing him due to his deformity. but evidence showed that they had procured 6 children within the last 8 years. The court held that this countered and rendered his claim inconsistent and was therefore inadmissible. So your wife was maltreating you due to your deformity, but you've had 6 children in 8 years. Oh my God. So the provision of section 9 of the Evidence Act was admittedly nebulous, that's vague or ill-defined, and may even cover some species of circumstantial evidence. Notwithstanding its wideness, not all matter of evidence would be admissible under this section. For example, inadmissible evidence will not be rendered admissible by this section. Number 2, facts which do not wholly relevant but tend to create prejudicial confusion of issues or waste the time of the court generally will be rejected. And if facts are collateral facts, if they do not have any connection with the main fact, they are not admissible. I think this has been self-explanatory so far, which is the reason I just kept on with the note. Because here we are talking about section 9, and section 9 in itself would be facts that on their own they are not relevant. That's one thing I need you to understand about section 9. Standing on section 9's own, they are not relevant. So for example, like we have seen in several cases that I cited today, let's start with the most funny one. The fact that they had 6 children in a marriage. I mean, that is very, very irrelevant to be talking about the number of children a person has in the marriage in court. Like, whose business is it that you have 6 children? Do you understand that? Ordinarily, they are not relevant. But when you juxtapose it with a fact in issue, it then makes 2 things. Look at it from 2 angles. Number 1, A, it is inconsistent with a fact in issue. B, it makes probable or improbable a fact in issue. Do you understand that? It is inconsistent with it. So in this last case where we have somebody with 6 children and he's saying that the wife is maltreating him because he was deformed, that's the case of ANAGBADO versus ANAGBADO. In this case, it is inconsistent that somebody who you are saying is maltreating you also gave you 6 children, which means you were able to have sex with her. She did not maltreat you and deprive you of sex because of your deformity. Do you understand? It is so inconsistent that the court will have to admit that to show, because it becomes proof that something is wrong here. Do you understand that? And then when you look at the case of CHIEKE versus OLUSOGA, where during the Nigerian Civil War, a person gave a memorandum to his wife and told his wife that if I don't come back, make sure you sell my properties. And after a long time, he did not come back. The wife sold off the properties. And then years later, he came back. And now he said Mr. OLUSOGA is in his house. And Mr. OLUSOGA is trying to prove his title. Now, what would have been ordinarily relevant to this case would be the title of other people, other houses. Like, how does that prove anything? Okay, I am trying to prove the ownership of my house, and I went to go and meet my neighbor. Hello, come and give me your C of O. Let me go and show the like. That is so irrelevant. It has nothing. But then, in this case, because it was the same memorandum that they used, that the wife used to sell the other properties, then the man had to go and meet them to give him the memorandum. He tendered the memorandum in court as evidence to show to the court that although this is otherwise relevant to this case, but then it then makes the fact in issue, the fact that I own this land through the memorandum that the wife gave to me, it then makes that more probable. Do you understand? It increases the probability that I am the owner of this land. It makes it more probable than less probable. So when we have facts which standing on their own, they are irrelevant. Standing on their own, they are irrelevant. But when you juxtapose it with any fact, either fact in issue or any relevant fact, then, we can say, yes, this particular fact becomes relevant. I think one example that sits well with this particular section would be an impotent man, somebody who the doctor has confirmed to not be able to, erect, so to say. His prick cannot stand. I'm sorry I use those languages, but I know this is teaching law, but I want you to understand to the best of your knowledge. So there's a rape case against him, and then counsel now seeks to tender that is an impotent man. If it was a murder case, then people will be looking at the man that, Shay, are you sure everything is all right at home? Because this is a murder case. But in a rape case, ordinarily, his impotency would have been a very irrelevant piece of document. That's the certificate of impotency given by the doctor. Would have been a very relevant piece of document. But because the elements to be proven in a rape case is that there must have been penetration, there cannot be penetration without an erection. That is it. There cannot be penetration without an erection. So if there is no erection and the doctor can affirm that there is no way this person could have been erected, then if it is admitted in court, it shows something. It is, number one, inconsistent with the facts in issue, whether or not there has been penetration, because he cannot even penetrate, because he cannot even erect. And number two, it makes even probable the fact that he couldn't have erected, and it makes it improbable the fact that there was a penetration. Do you understand? So these are things that are otherwise useless, otherwise not relevant. But when you juxtapose it with relevant fact, they automatically become relevant. And that is what, section 9 is talking about. And then the last case cited for section 9 would be the case of AKINGBADE versus ALIMOSHO, which is still similar to the case of CHIEKE versus OLUSOGA. But in CHIEKE versus OLUSOGA, they were looking at the properties that were sold using the memorandum. They did not necessarily have to be in the same area. But in this case of AKINGBADE versus ALIMOSHO, the plaintiff who had sued for declaration of title tendered in evidence deed of conveyance executed by his vendors in favor of persons who had bought surrounding lands. Plaintiff's intention was to prove that his title was valid, since the neighbors who had acquired theirs from the same vendor had long developed their land. So in this case, juxtaposing this from CHIEKE and OLUSOGA, in CHIEKE's case, he was using a memorandum. So the building were not in the same vicinity. But in the case of AKINGBADE versus ALIMOSHO, his own title was being questioned. But he got the title from the same vendor that every other person in the vicinity got their title. And then when he got to court, he then had to tender the deed of conveyance that his vendor gave to him, and also a deed of conveyance that same vendor gave to the others, and he tendered it in court. And then the court said, yes, this is good practice, this is okay. It might not prove in exact fact, but at least it tilts the scale to your favor. Although the other party can still rebut, but it tilts the scale to your favor. It makes this particular fact a relevant admissible fact. Do you understand? On a normal day, the deed of conveyance of the next person is not relevant to this proceeding. The deed of conveyance of your neighbor is not relevant to this proceeding. But because you got the deed of conveyance from the same vendor that gave you your own deed, and now your own is questioned, it means that the other person's own, we should also look at the surrounding circumstances. Because when we can look at the surrounding circumstances, then we can arrive at a particular conclusion, whether or not it is probable or improbable that your deed or your title was valid. And that is it. So with this, I end my class on section 9. In my next lecture, we'll be talking about section 10. And section 10 basically are facts relevant when damages are claimed. Fact relevant when damages are claimed. I'll see you in my next class.